and Justices of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning, ladies and gentlemen. Our first case this morning is 2019-273 in the matter of the complaint of Cynthia Wingo versus Nationwide Energy Partners, LLC et al. For Ms. Wingo, Mark Witt.
Chief Justice O'Connor, may it please the court, I would like to reserve 5 minutes of my time for rebuttal. Equality and fairness are such important principles that we carve those words all over our courthouses and public buildings. Cynthia Wingo was not treated fairly, and that's why I'm here today. Ms. Wingo's complaint alleges several theories for regulating Nationwide Energy Partners, or NEP, as a public utility or electric services company. The commission believes it dismissed the complaint for lack of subject matter jurisdiction. What it actually did was to exercise subject matter jurisdiction and reach the issues raised in the complaint on the merits. Now, our brief explains why this violated Revised Code Section 4905-26, the complaint statute, and 4903.082, the discovery statute. Let me be clear that we are not disputing the commission's ability to look outside the pleadings to resolve issues of subject matter jurisdiction. But there was no need for that here because the commission had already ruled just a few months earlier that it had and would exercise subject matter jurisdiction in complaints against utility resellers like NEP. So subject matter jurisdiction was already apparent from the face of the complaint, and there was no need to go outside the pleadings to consider the material submitted by NEP with its motion to dismiss. Now, the same order that acknowledged the commission's subject matter jurisdiction in reseller complaint cases also acknowledged the need for factual development through the hearing process. And the commission said, quote, "Our consideration whether any individual reseller is a public utility must be made after the development of an evidentiary record in a complaint case." And that's from paragraph 31 of the June 2017 commission order in its investigation. It's in the supplement at page 3106. What essentially happened here, Your Honors, was that the commission basically converted the practical equivalent of a Civil Rule 12b6 motion into a Rule 56 summary judgment motion, and it did so without notice. And when Ms. Wingo sought discovery of the very information that NEP submitted and the commission considered and relied on in its order, Ms. Wingo was unable to obtain that discovery. NEP moved for a protective order to prohibit the discovery, and the commission never ruled on the discovery issue. Instead, it issued its order dismissing the complaint and citing Ms. Wingo's purported failure to dispute NEP's evidence as the basis for its decision, overlooking the fact that Ms. Wingo was precluded from disputing NEP's evidence. Now, the commission acknowledges that its rules, unlike the Ohio civil rules, do not allow for summary judgment. But even if they did, this court has long recognized that it's a due process violation, as well as violation of the civil rules, to convert a motion to dismiss into a motion for summary judgment without prior notice. And that is essentially what happened here. Again, Your Honors, the basic issue in this case is one of fairness. And I know that the briefs really get into the weeds procedurally and substantively on the matters alleged in the complaint and whether utility resellers ought to be subject to regulation. Those certainly are important questions, but they're questions that can't be answered until the commission allows the development of a full and complete evidentiary record. And that simply has not happened. We would ask the court to reverse the order dismissing the complaint and remand this case to the commission with instructions to give Ms. Wingo her day in court, figuratively speaking, as mandated by Ohio law.
Assuming we agree with you, Mr. Witt, about that issue, should we say anything about the commission's use of this modified Schroer test?
Yes, and it's somewhat misleading to even describe the test as a modified Schroer test because it's actually, in many ways, a reversal of the Schroer test. But it may be sufficient for the court to simply point out and call attention to its precedent going back at least to the 1930s, indicating that whether an enterprise is engaged in the business of a public utility depends upon the character of the business in which it is engaged. In other words, there is no fixed or bright line test of when an entity is or is not a public utility. Perhaps the Schroer factors may be relevant in some cases, but those factors cannot be applied.
Isn't there a statute that says what's a public utility? Why shouldn't the PUCO just apply that?
We agree the commission should apply the statute, and the statute defines a public utility by virtue of the business in which it is engaged, which, as this court has recognized, is not a self-applying definition. So by necessity, ultimately it's the complaining party that has the burden of proof, and whatever factors the complaining party wishes for the commission to consider ought to be considered, and the commission can explain in its order whether it views the factors persuasive or not, and give a full and complete analysis. Again, and the reliance on Schroer is problematic because that case, as well as Pleasure, dealt with a very specific factual circumstance where you had landlords whose primary business was being a landlord who incidentally resold utility services to their own tenants. That was Schroer. In the case here, we're dealing with an entity whose primary business is not that of a landlord, but of an entity that resells utility services to consumers who are not its tenants. And that's its primary business. And again, we're not saying the Schroer factors are necessarily irrelevant, but they are simply insufficient to render a conclusion one way or the other. Again, if we go back to the statutory definition, that statutory definition necessarily requires full development of an evidentiary record. And as the court has recognized, whether an entity is a public utility is a mixed question of law and fact. And mixed questions by their very nature aren't susceptible to bright line Schroer tests or modified Schroer tests or anything of the sort.
You also, I believe, raised the issue about the commission granting rehearing for the purposes of deciding whether to grant rehearing, in essence. And I'm sympathetic to that argument, but I'm trying to understand what it means for your client. If that was constructively a denial, does that mean you've missed your time to appeal?
We don't believe so, Your Honor, because if the statute is strictly construed, as we believe it should be, to require an affirmative grant or denial of rehearing within 30 days, then any action other than an affirmative grant or denial on the merits of the rehearing application would constitute a denial of rehearing by operation of law.
Well, that's my point, though. If that's your argument, then hasn't your time to appeal run? Introduce your time to appeal if that was a constructive denial?
No, Your Honor, because we had already, we sought rehearing from I don't recall offhand whether it was the first or second entry on rehearing, but we basically treated the first denial or the grant of rehearing for purposes of further consideration as a denial and timed our appeal accordingly. So if anything, we filed early, not late.
Okay.
If there are no more questions, I'll reserve the remaining time for a rebuttal.
Thank you. Mr. Eubanks?
Good morning, members of the court. I would like to reserve 3 minutes of my time for Nationwide Energy Partners Council. This case really just involves a complainant that did not plead properly. There is no notice pleading before the commission. And in fact, for the appellant to have pled properly before the commission, she needed to only note 4 things. Number 1, that RC 490526 requires a complaint to state reasonable grounds that a public utility has harmed you before you are granted a hearing. Number 2, that OAC 4901901B requires, and I quote, a statement which clearly explains the facts that constitute the basis of the complaint, unquote. Number 3, if a complaint is brought by a tenant over whether or not a landlord or associated companies should be treated as public utilities because of the submetering services that they provide, then this court in Pledger ruled that the tenant has to allege reasonable grounds through specific facts under the Schroyer test. And 4.
Well, wait a second. The commission didn't apply the Schroyer test, though, did they?
The commission did. The commission.
Well, they changed it, right? They said they were applying a modified Schroyer test.
The commission stated that even if it had applied the Schroyer test unmodified, it would have come to the same conclusion. Well, actually, but
it did that by considering evidence outside of the pleadings, right?
No, it did that by considering the pleadings themselves itself.
And the affidavit you submitted.
No, the commission stated that if you take all the facts that are listed in the complaint to be true, it reached the conclusion that the complainant did not allege reasonable grounds.
Then why did the commission cite all this other evidence then?
Because
it wasn't in the complaint. It was your evidence.
As a matter of process, what happens is you have a complainant file their complaint, and then the rules allow the respondents to file a motion to dismiss for failure to state reasonable grounds. So the commission did consider all the arguments that were made in those motions, but at the end, the commission reached the conclusion that they dismissed because the complaint was insufficient. It did not state reasonable grounds under the Schroyer test, under the modified Schroyer test, and it did not state reasonable grounds for specific harm to Wingo herself.
Help me understand this relation of the modified Schroyer test to the statute, because I read the statute and I read the modified Schroyer test, and they really seem to have almost no connection to each other. Can the commission just make up a test without any statutory basis?
Well, the Schroyer test has already been approved by this court.
But that's not what was applied. So
the third prong of the Schroyer test is what is modified by the modified test.
Right. And so essentially PUCO is saying we are only going to regulate certain kinds of these resellers, right?
Okay.
Essentially ones that's charge more than others. That's essentially the modified Schroyer test.
So let's think about this. A sub-metering company, what they do is they pay the major utility, in this case, it would be AEP or the Reynoldsburg Water and Sewer. They take the bill, they pay that bill. Then they go read the sub-meters, and then they apportion the bill to the tenants. The only way that they can harm the tenants is if they charge more than what's charged to them through the through AEP or through Reynoldsburg. So when you're dealing with a sub-metering company, that is the relevant issue. There is no other issue. That's the only function that they perform.
Excuse me a second, but I mean, this is very different, right, than the situation that the Schroeder test was developed for, where you had essentially a landlord who was passing through the cost to the tenants and apportioning them. I mean,
Actually,
here you have someone who is making significant profit by doing this.
Your Honor, actually, I disagree. I believe that this is exactly analogous to pleasure, and here's why. In that case, the landlord was the sub-metering company. The landlord was the one that was paying the utility first and then apportioning the bills. Now, the only difference here is that the landlord now has an agent that is doing that service for them. But that shouldn't change the analysis any. We shouldn't say that landlords can't go out and have a third party do those functions for them. So what you should do is,
but this is a lot different. You have to admit than just a landlord saying, "Okay, I'm going to divide this up and I'm going to collect the money." When you have someone who's out there negotiating, and then charging tenants for these services.
No, the function that NEP provides for the landlord is the same function that the landlord would have to provide for themselves if they didn't have an agent to do it for them. And the analysis shouldn't change at all simply because the landlord sought an agent to perform those actions on their behalf.
But the analysis does change, right? Because you're regulating some of these sub-metering companies and not others, depending on how much they charge.
Again,
I mean, it isn't essentially what PUCO is doing is regulating under the guise of a jurisdictional assessment. So if you charge above a certain amount, we're going to regulate you.
Okay, again, when you bring a complaint against a public utility, you bring that complaint and you have to not only state that you're bringing it against a public utility, but you have to allege some harm. That harm normally divides into one or two categories. You either are alleging discriminatory action or you're alleging an unjust rate. Those are the two types of harm. Now, when we're talking about a sub-metering company, the harm that specifically applies is an unjust rate. Now, if you have a sub-metering company that is not charging you any more than you would have been charged through AEP or through Reynoldsburg Water and Sewer in this case, then it is hardly worth elevating them to the point of a public utility when there is no unjust rate to begin with.
So you really are saying, okay, we're going to decide whether we're going to use this jurisdictional assessment to decide whether or not something's unjust, and that makes them a public utility or not?
No. The fact is that even if it was over that rate, that's just a threshold to get them to a point where they would even qualify as a public utility. You would still have to then prove your case that it's an unjust rate.
Sure, but I guess what I'm struggling with is really what you're articulating to me is a policy judgment of what should and should not be regulated, but you're doing it under a jurisdictional assessment. You're using the jurisdictional statute to in essence regulate with.
Okay, you do have to plead jurisdiction in order to have a hearing before the commission.
But you've determined what jurisdiction is based on whether or not you think something rises to a certain level that it deserves to be regulated.
Okay, the Schroyer test is not modified in its entirety. There are still two other prongs. So it's not as if the modified test has narrowed it down to just that one consideration. The complainant could fall under one of the other two categories. It could plead that the submetering service is availing itself to special benefits available to public utilities. It could plead that that the submetering company is making utility services available to the general public rather than just to the tenants. It's only the third prong that has been modified. So there's still three angles of attack that any complainant can plead in order to get over the hurdle in their allegations in order to move on to a hearing.
Mr. Eubanks, in your view, if the PUCO doesn't have jurisdiction, where would this kind of challenge be appropriate?
This type of challenge that would be appropriate in a landlord-tenant action. Really, all this action is brought by Ms. Wingo in this case. It's just a challenge of Schroyer, a challenge of the modified test, and a challenge of whether or not you have to plead harm in your complaint. She has not alleged any harm whatsoever. She has not alleged any of the factors under the original Schroyer test, and even the modified test that requires her to plead the relative price test, she has not pled that as either. The relative price test is a very easy standard for any complainant to meet. That type of information should be readily available to any complainant who's going to file a complaint. All they have to do is have access to their bills and have access to the utilities tariffs. Ms. Wingo, in this case, had learned counsel who would have easily been able to get that information. She simply did not plead it. She acted as if all of the case law that came before, all the statutory law and the administrative code did not exist and turned it on its face. I mean, this court has already said that tenants are the consumers, yet in the complaint, has already said that landlords are the consumer, yet in the complaint, Ms. Wingo says that the tenants are. This court has already said that the AEP in Reynoldsburg, in this case, would be the suppliers. Ms. Wingo says, no, the landlord is the supplier. This court has already said that RC 490502 and 03 are not self-applying, but the complaint says, no, they are self-applying. This court has already found that you cannot just say that because a company is a reseller, a redistributor, or a submetering company, that they automatically fall under the jurisdiction of the commission. Yet that's what the complaint says. This court has already said you do have to plead subject matter jurisdiction, because if you're pleading that the entity is a public utility, you're necessarily pleading that they come under the jurisdiction of the commission, so you are pleading subject matter jurisdiction. The complaint says you don't have to do that. This court has already said, and every court in the land says, you have to plead harm that affects you individually, not harm that affects everyone else in the world other than you. And yet the complaint only alleges harm that happens to other tenants, nothing that happens specifically to Ms. Wingo. This court has already said that the commission does not hear landlord-tenant matters, yet the complaint only makes allegations about landlord-tenant matters, as well as the Sherman Antitrust Act and the Fair Credit Act and the Privacy Act and the Equal Credit Act, all things that are not relevant to anything that the commission regulates. And finally, even when it comes to the modified test, the appellant only pleads her monthly bill. She does not plead what the utility charged her. Therefore, she cannot make a comparison. And because she cannot make a comparison, she cannot plead the relative price test. As for the rehearing matter, the commission can grant itself a rehearing It only has to identify what the purpose is for the rehearing, what the purpose is. They do not have to.
Well, for some reason, the legislature chose 30 days to rule on a motion for rehearing. I mean, isn't the commission's practice essentially saying there is no timeline?
The commission did make a ruling within 30 days.
Well, it made a ruling that we're not going to rule and we're going to rule later, essentially. I mean, how is that consistent at all with the statute that says that you're supposed to rule on these in 30 days?
Okay, I really don't see any difference between what the commission did here and if it would have granted itself a rehearing to consider additional evidence. Either way, the commission would have been given itself additional time to reconsider what happened below.
So the commission just has carte blanche to give itself additional time, regardless of what the 30-day deadline is. That's essentially where we are.
Where we are is, if you file for a rehearing, the first body that gets a chance to address whether or not the order was correct or not is the commission. And when it does that, it can grant itself time in order to reconsider the arguments that you're making as to why they should overturn their decision. They did so in this case. They followed RC 490310 to the letter. There is no requirement that they curtail the additional time that they can grant themselves, and there is no limit.
Well, there is a 30-day limit in there. That seems to have some. It seems like it should have some meaning, shouldn't it?
And it does have a meaning. Before 30 days, they granted themselves additional time to reconsider the matters before.
Do you think that's what any member of the state legislature thought that meant when they voted for it?
Well, we already have a case, Consumers Councils versus Public Utilities Commission of Ohio.
That wasn't my question. Do you think that any reasonable member of the state legislature, when they voted for that 30-day limit, thought that meant that the commission would give itself indefinite extensions of time to decide something?
In this case, we do not have an indefinite extension of time. We have a commission that made a very timely decision on the rehearing process.
So again, do you think that's what the state legislature meant when they voted for that? You think that's what a reasonable person voting for a 30-day time limit thought that meant?
Yes, Your Honor, I agree with this court in its ruling in Consumer Council versus Public Utilities Commission of Ohio. You reached the same conclusion that I agree with now, that the commission does have that power. And excuse
me, Mr. Eubanks, though, was that just dicta? I mean, you mentioned it as if it's a holding. Is it a holding in that case?
It is a holding in that case. And furthermore, it's a plain reading of the statute. Statute simply says that the commission must identify the purpose for which rehearing is being granted. It does not have to consider additional evidence. It does not have to hold a new hearing.
Counsel, you've used your time.
Okay, thank you. With that, I would ask that this court uphold the commission's order.
All right. Mr. Settineri, your co-counsel has cut in deeply to your time, so you have about a minute.
Thank you. Chief Justice O'Connor, may it please the court. My name is Mike Settineri on behalf of the intervening appellee, Nationwide Energy Partners. Some very quick points. Strongly agree with Mr. Eubanks. The PUCO's rule require a heightened standard for pleading, much more than notice pleading. In this case, it's important to realize it's about Ms. Wingo and Ms. Wingo alone. It's not a class action. And she had to plead facts, and she did not. And as to the 12B6 discussion, this is analogous. The motion to dismiss was analogous to a 12B1. You can go outside the pleadings on a 12B1. And the commission's rules actually expressly allow motions to dismiss for lack of jurisdiction. That was what was done here. Most importantly here is for you to understand what Nationwide Energy Partner is and is not. And starting with is not. It doesn't have the right of eminent domain, does not provide service to the general public. It has contracts with its customers, landlords, property managers, to help them manage their complexes. And importantly, Nationwide Energy Partners, it helps the landlords and property managers. It reads meters. It repairs things. It invoices tenants and collects charges, but it isn't the utility account holder. It does not take title. It does not resell electricity or water. The record is very clear on that.
Counsel, if Ms. Wingo had her own meter at her own residence, would she be paying less than what she's paying with the management by Nationwide?
Yeah, well, again, her utilities are through her lease with her landlord, Creekside. If she had her own condominium, let's say, directly connected to AEP Ohio, she would actually be paying more through AEP, and the record is clear on that. And I know AEP was a party in the case. It did not dispute Nationwide Energy Partners' calculations in its motion to dismiss. So she actually would have paid less. She paid less through the landlord arrangement. She would have paid more through AEP. And importantly, I want to emphasize Nationwide Energy Partners' role here. It is not the reseller. It is not. And that's why this case fits squarely within Pledger, because Pledger related to the landlord-tenant relationship, that's what we have here. Your utilities are through the lease. And that fits with almost 100 years of case law through this court, starting in 1928 with the Jonas v. Swetland case, it's in our brief, to 2006, First Energy versus PUCO, a unanimous decision. And Pledger, which was dismissed by the PUCO through a motion to dismiss very quickly after a complaint was filed. And again, another unanimous decision by this court.
Thank you. Thank you, counsel.
Thank you very much.
Mr. Witt.
Ms. Wingo,
you're going to, oh, there you go.
The claim is made that the complaint was not pled properly. I would invite the court's attention to page 1002 of the supplement, which contains our 20-page, 123-paragraph complaint. If it is improperly pled, I will gladly consume it for my lunch. Both counsel indicated they talked about, what NEP does or what NEP is or is not. Certainly they have their own explanation and characterization, and if that's what they want to try at the PUCO, that's their prerogative. But Ms. Wingo is entitled to test these allegations and present her own evidence indicating the true character of the business. That this
Counsel, what is Ms. Wingo's damages here? Her harm?
Well, her harm, we allege, notwithstanding the claims that she pays a lower rate, the only independent analysis or comparison of AEP to NEP was performed by the Legislative Service Commission, and that is in the record, and it indicates uniformly that NEP's rates are higher. And when asked to explain that difference, NEP couldn't do so. That is at the supplement 3125. Moreover, the rate that Ms. Wingo pays is irrelevant to any consideration of whether NEP is a public utility, and that is the question. And in fact, in the original Schroeder case, the commission specifically rejected staff's recommendation to include this price comparison as one of the factors.
Counsel,
the commission rejected that.
Let me ask you a quick question. Your client requested to take a deposition in this case, and that request was denied. Is that correct?
That's correct.
And what facts do you believe you would have established had you been able to take that deposition?
Well, we wanted to get under the hood on some of the contracts that are referenced in the affiant's affidavit. They're referenced, but we've not seen them. We wanted to know the basis for the numbers that they used in their rate comparison, what they included, what they didn't include, to basically cross-examine the evidence. And as we're all aware, the reason we're meeting today by video conference is because there's a public health threat that's unprecedented in this state. And the commission can certainly, and not only can, it has issued orders to public utilities within its jurisdiction to do or not do certain things during the pandemic. And the tens of thousands of Central Ohio consumers who have no choice but to receive service from NEP don't have those protections. There's essentially, George Orwell talked about all animals being equal, but some being more equal than others. And that is how the commission has come to view these submetering arrangements, where we have one class of consumers in this state that receive public utility service and have the protections and safeguards offered by the PUCO. And another group of consumers who don't have those protections and have no recourse. And you can't get to the courthouse without going past numerous residential buildings where NEP is the service provider. And these buildings are apparent from the PUCO building.
What about what they say, which is, well, we don't need to worry about these essentially because they're paying less or at least no more than they would be paying from AEP anyway.
Well, Ms. Wingo originally came to me because she was being threatened with shutoff a week before Christmas. Now, that would not have happened with AEP because AEP is subject to the commission's winter disconnect moratorium that is issued every year. So that is a type of harm. Even if she's paying a lower rate or the same rate or whatever rate, she's not receiving the protections and the benefits, for example, that AEP customers pay. The only reason NEP charges the AEP rate, let's remember, reflects AEP's cost of service. And AEP's cost of service includes various riders the court's familiar with, energy efficiency, electric vehicles, all sorts of things that consumers get. NEP customers, even if they pay that AEP rate, don't receive what AEP customers receive for paying the same amount. So they're really hit from both ends. And again, we reject fundamentally the notion that the only inquiry here is whether the consumer pays a higher rate. It has, if the service was $1 a month, it would not change the statutory analysis of whether this enterprise is a public utility.
Thank you. You've used your time.
Thank you.
We'll take the matter under advisement and you'll be notified of our decision.